is known to have made dramatic changes in the law regarding domestic violence and the protection of victims, especially women. The early 70s highlighted an increase in awareness on domestic violence, with activities including re-examination of criminal justice law and policy. Majority of the agenda was pushed forward by feminist activists, shining a light on male violence towards women. Examples include refuge centres for women, which in turn created what we know today as Women's Aid. Prior to 1979, there was already a lot of headway in legislation concerning domestic violence, such as the Domestic Violence and Matrimonial Proceedings Act in 1976 and Housing Homeless Persons Act 1977, which accepted domestic violence as a cause for homelessness. Between 1976 and 1978, courts also allowed personal injunctions protecting women or excluding violent men from the home. These are now found in the Family Act 1996. These early 1970s acts were often criticised for their limitations. However, they did raise the profile of domestic violence for some professionals and practitioners. As victim support became the focus of attention, talk began of rebalancing the criminal justice system in order to help victims. During the late 70s and early 80s, British police made a degree of headway in understanding domestic violence. For example, since 1975, both men and women are expected to interview female victims, whereas before only female officers would. An introduction of white paper and other Home Office suggestions emphasised duty to protect victims and change the police views, and ensured good records of each investigation are kept to assist evolution of laws in this matter. Police also worked closely with other relevant agencies such as Women's Aid, hospitals and schools, so multi-agencies' approach to domestic violence began to take shape. 1979 already was a great year for women, with Margaret Thatcher becoming Britain's first Prime Minister, but also because 6 women were acquitted in the Reclaim the Night trial in London, which concerned sexual violence. In continuation to raising awareness, in September 1981, Shocking Pink Collective was set up. They issued publications emphasising certain topics, including violence against women and many others. In 1989, Kiranjit Ahluwalia was convicted of murder. Ahluwalia poured petrol on her husband who was sleeping and then set fire to him. He later died from his injuries. The couple were in an arranged marriage for 10 years where the husband had been violent and abusive throughout the duration. On the night of the killing, he threatened to kill her with an iron and told her he would beat her the next day if she didn't provide him with money. At her trial in 1989, she admitted to killing her husband, but raised the defence of provocation. However, the jury still convicted her of murder. She later appealed that the judges directed the jury wrongly and also raised the defence of diminished responsibility. It was held that the judges' direction on provocation were correct and therefore the appeal on this ground was unsuccessful. However, the appeal was allowed on the grounds of diminished responsibility. The court stressed that it was exceptional that fresh evidence would be allowed. A retrial was ordered due to the finding of medical evidence showing that Ahluwalia was suffering depression at the time of the trial. This case attracted a lot of media attention, mainly from the Southall Black Sister launch, Free Kiranjit Ahluwalia campaign, as they felt that miscarriage of justice had occurred. They set out to reopen the case as the life sentence that Kiranjit was serving was believed to be unjust due to the severity of violence she suffered from her husband. The campaign also joined forces with other women's groups concerning battered women who kill and the criminal justice system. By doing so, they highlighted the male domination of the criminal justice system and the law that affects all women. The case received support from other unexpected communities who actively raised awareness on domestic violence and situations of women trapped in violent relationships. In 1992, Ahluwalia was released and her original conviction was quashed and reduced to manslaughter. Her case changed the definition of provocation in cases of battered women, so to reclassify her crime as manslaughter instead of murder. In the same year as this, it led to the freeing of Emma Humphreys and Sarah Thornton.
In addition to the effects of Ahluwalia, the case of RVR was having its own significance during the period of 1991 towards the changes in law concerning violence against women. Here, the House of Lords overturned the matrimonial exception to rape, making it illegal for a husband to rape his wife. Before this case, it was deemed acceptable for a husband to have non-consensual sex, as it was assumed consent was given when married. For example, in 1984, a Court of Appeal judge had said that marital rape should not lead to a prosecution because it would prevent rehabilitation of the marriage. From this, the statutory law eventually changed in Criminal Justice and Public Order Act 1994. In 1993, with the help of lobbying by women's organisations around the world, the United Nations Declaration on the Elimination of Violence Against Women affirmed that violence against women violates their human rights. During the period of 1995 to 1996, the introduction of Family Law Act was coming to light. The injunctions which were introduced there are now coherent in the Family Law Act. This act was amended by the Domestic Violence Crime and Victims Act 2004. It enables a woman to obtain an injunction from the court to protect her from abuse. An injunction is a type of court order which forbids an abuser from doing certain things, such as being violent, or orders him to do things such as leave the home. There are two types of domestic violence injunctions available under the Family Law Act. There are non-molestation orders and occupational orders. However, there are still restrictions to this act. For example, you can only apply for such order if you are associated to your abuser. Another restriction is if you're getting an order to protect yourself or any other relevant child. There is a statutory definition of what is considered a relevant child. In 1997, Protection from Harassment Act was introduced. If you're not associated to your abuser, then you are able to obtain protection through this act for harassment or fear of violence against someone. Finally, in 1997, similarly with the Ahluwalia case, the Southall Black Sisters secured a first ever conviction of marital rape in the Asian community. His members of family were also sentenced for abusing his wife.
We are demanding, we feel quite reasonably, rational changes in thinking, in policy, in attitudes towards people, and we will go on demanding them, even if it means breaking the law.